Hi, I'm Michael Potter, and today we'll be talking about the limited liability limited partnership. Now, all 50 states do recognize limited partnerships as a planning tool for business or investing or even estate planning. However, the level of protection that's offered by those limited partnerships is by no means equal. Now, in the last few years, several states have begun to adopt a more advanced version. It's known as the limited liability limited partnership, also known for short as the triple LP. Well, what makes the traditional limited partnership all that different from the newer or more advanced version known as the limited liability limited partnership? The primary difference is that any creditor is limited to one sole remedy. Now, the charging order is a severely restricted remedy, and only when the general partner decides to make a distribution, which is discretionary, can that remedy be applied, and then only under very limited circumstances. Now, the general partner of your limited partnership is probably going to be you or maybe an entity that you control. Either way, the general partner is the one who really makes all of the day-to-day operational decisions, investment decisions, and controls the everyday operations. Now, as the general partner, you can be compensated for being in that management position because you've got the responsibility of making the day-to-day decisions, choosing the investments, and so forth. Number two, and this is important for the limited liability limited partnership, you get the same protection, the same asset protection as the limited partners do. Now, in the traditional limited partnership, it is the limited partners who enjoy the liability protection. But here, with the triple LP, the general partner and the limited partners have the same degree of liability protection. Now, who should be those limited partners? Well, you have a variety of choices. In the first instance, you could use your fellow investors, other persons in your family, your circle of friends, acquaintances who want to do business with you. So perhaps you could come together as individuals and be limited partners. That's certainly a first choice. Now, on the slide you're about to see, I'd like you to look over on the right-hand side. And I'd like you to notice that there are two trusts as limited partners. This might be a much better way to go. Living trust as one of the limited partners, and you've got the Wealth Preservation Trust as the other limited partner. But combining these two, you've got not only the tax-efficient planning, but you've also got the privacy and asset protection planning that we really want. Now, each of these two trusts are covered under separate videos, which I hope you'll take a look at. Now, you have some options with respect to who should serve as the general partner. There are about three approaches that I like. The first of which is a simple one. You can serve as the general partner. That's just fine. A lot of clients do that, and that works well in many cases. A second approach, and this may be more sophisticated, is to use a corporation as the managing general partner. That could give you some benefits with respect to privacy and asset protection, and also allow you to provide health care benefits, retirement benefits, and so forth as you are paid to be the general partner through the corporation. A third and final option for your general partner of your limited partnership might be to use something a little more sophisticated to have a lower profile and better privacy, and that would be the use of the Nevada Privacy Management Trust. Now, you have several different options with respect to who should be the limited partners. Now, you could have family members as limited partners, and that's often done in the United States, where you have other family members, maybe children, maybe your siblings, maybe your parents or cousins, that could serve personally as limited partners. However, in my view, that's not quite as safe as you could go. It might be safer to use a trust as the limited partner, and in specific, to use a combination of trusts as limited partners. That might be a much more private, safe, and efficient way to go for purposes of estate planning, tax and privacy, and also asset protection from lawsuits. Now, as you just saw, there's several different choices. I like these three choices that I've laid out before you: the living trust, the Wealth Preservation Trust, or the Dynasty Trust. Now, I always like to include the family's living trust as part of that plan, and then I like to have a choice between either the single generation Wealth Preservation Trust or the multi-generation Dynasty Trust, depending upon how many generations of your family members you want to provide for and to protect. Now, there's some choices to be made with respect to what exactly your limited partnership should own. I like looking at it this way. Now, first of all, I like the limited partnership to own what I call direct investments. Those would be mutual funds, trading accounts, stock brokerage accounts, and so on. Then I'd like it to own any corporations through which you do business with the general public, whether it's a retail business or a service business. Now, for better layering and further protection from liability, it can also own any LLCs or limited liability companies through which you own either commercial or residential rental real estate for passive income. Well, we've covered a lot of material here. I hope you've really enjoyed it. If you have any questions at all, please don't hesitate to get in touch with me. I'll be glad to help you in any way I can. I'm attorney Michael Potter, and I look forward to hearing from you.